Hello, and we thank you for joining us today for our 4A's webinar. My name is Shelly Campbell, and I help head up the learning and development activities here at the 4A's. We are entering another session of our Advertising and the Law series, and please introduce to you our thought leader here today, Ron Urbach, for today's session, Social Media Dynamics. In concert with the integration of social media elements with web and mainstream media, it has become necessary to understand how advertising rules, regulations, and best practices apply to rapidly evolving social media activities. So in the next hour, Ron will take all of you through the social media rules of the road. And before we start, let's review some logistics with all of you. You can hear us, but we cannot hear you. If you have any problems reading the presentation on your computer, it could be a security issue on your end, and you may need to contact an IT person. If you find that you need to contact us via email, please send an email to webinar@aaaa.org. We'll help you with any technical issues, and if you disconnect for any reason, just go back to the email invitation and log in again. Now, as I mentioned before, our wonderful webinar leader here today is Ron Urbach, who is chairman of Davison Gilbert LLP and its management committee. He is also co-chair of the Advertising, Marketing, and Promotions Practice Group. His clients consist of numerous multinational, national, and regional advertising agencies, including some of the top creative agencies in the world. Now, at the end of the webinar, we'll have a few minutes for some Q&A. However, we encourage you guys at any time to send any questions you'd like to ask Ron. So in the go-to panel, you'll see a questions section. This is where you can type in any question you have, clarifying something, things that you guys are dealing with that you have questions about. Just let us know, and we'll save that for our Q&A at the very end of the webinar. We also encourage everyone to do some social tweeting about what you guys think, and just ask for you at our hashtag 4A's webinars. And last but not least, we're going to be throwing a few polls your way. We love to kind of hear what you guys are thinking on your end, so keep a heads out for that. And without further ado, please welcome everyone, Ron Urbach.
Hi, everybody. Thanks a lot for taking time out of your day to spend a little time with us. So we have a lot to cover, and I'll do the best I can to cover it, and let's move it forward a little bit. So hold on one second. One second. All right, first let me just show you a little video and just sit back and relax, and hopefully it'll play on your end.
All right, guys, ready? Think awesome cosmetics. Take a deep breath. This is for real. It's on Instagram, folks.
Oh, and Pinterest, just because.
Oh, you would. Yeah.
There's Instagram, love the color at Awesome Cosmetics, hashtag lips, hashtag face lips, hashtag.
Hashtag, I needed to have sent that out like 60 seconds ago. I'm sending this, okay?
We don't want another Catherine Hake with Wayne Reed problem.
That's right, she's sued.
We can't wait.
Guys, there's Jared Leto, and look who Ryan Seacrest is about to interview. Katy Perry.
He just nailed it. Rihanna G Studio. Someone check out their Twitter feed.
She's getting ready to put her hand in the mannequin to show off her new manicure. Perfect. Got an idea? Tweet about our new luminescent nail polish, how it matches Rihanna's awesome Chanel dress.
If Rihanna complains, we just pull a little Pharrell Arby situation where we buy the dress, donate the money to charity.
That's a great idea. Let's do that.
Tweets out, let's do hashtag nail cam, hashtag Rihanna's VMA.
What if we post the photos of Rihanna's Chanel dress on Facebook and Pinterest pages?
Yes, absolutely. All right, guys. Let's love us some monster nail polish sales.
You know, I think...
Look, man, there's no time to think, all right? Look at Jennifer Lawrence's new haircut.
I'm all over it.
Our new styling job?
I think she looks like Jade.
Yeah.
I'm posting this. Wait. This, man. Why are you even here? Dude.
Marco, it's huge if Seth's right.
Yeah, and it sucks if we miss it.
And I'm right.
We wait. Marco, a friend just gave me a tip. We have to avoid Beyonce because her lawyers are in a huge fight with Levon, the French shampoo, her lawyers or whatever, and it's a big thing all because of a tweet.
Guys, we don't need it. We're trending.
Yes!
Yeah!
All right!
Let's get excited.
So, hold on. It's not doing this. So just to let you know what that was, so that's, we call it social media war room. It's really the interaction during the course of an event between the brand and agency and, to be frank, counsel to kind of move forward and interact with what's going on. And you'll see a pickup on various issues that are ongoing at that point in time, such as the references to celebrities' names, the reference to a particular event that's ongoing, all happening fast-paced, all happening in a sense real-time, and that's something that we have done and do with our clients on and around so-called, as I call them, tentpole events, Super Bowl, Academy Awards, the Oscars, the Tonys, whatever it might be. Secondly, that is, in fact, to be frank, somewhat old at this point, because what's happening now, as you saw in the most recent Super Bowl, is this reality. There is no time to just work on and then post. It's really all about live streaming. So in a sense, it's live. And how do you really do the discussion that you saw ongoing before you? And that's really difficult, and the only way we can deal with it is by training, which is one purpose of the meeting that's here. So we got our PowerPoint back on, and sorry about the delay that you saw in the video. So if we have time, what we're going to talk about is going to be joining the online conversation, a distinction between advertising versus editorial, which is extremely important for you to understand. And to be frank, in light of what's going on with the Trump administration, it's very, very real. Some basic advertising rules, how to apply, how to use social media content, and what are the risks, celebrities, hashtags, endorsements, and native. Each one of these could be, by the way, a segment, but we're just going to kind of talk about it topically at the very high end. Next. Okay, I can use this. Great. Great. Okay. So a lot in social media is a discussion about how does a brand join the conversation. And that's really what they view it as. A brand or an agency will view this as being a continuation of conversation that occurs that you would do in your normal lives, personal lives. You use social media for a lot of reasons, but ultimately to communicate. Now, when a brand does it, you have to understand the fact that what you're doing in terms of your personal life is really different than when you're doing it in a professional life. And the rules that apply, what you could do personally, are different than what you could do professionally. And that may seem like a contradiction in thought, but that is a reality. Because at the end of the day, the social media communication or conversation is advertising. And it may not look like a television commercial or a print ad or an outdoor billboard or whatever, a promotional direct mail piece. It is still advertising nonetheless. And even though it's conversational-like, it is still all the rules that would apply are going to apply in this area. So some of the issues that you have to deal with, as we saw in the video before, is going to be issues of rights of publicity, which is the laws that are going to protect the individual celebrity, or to be frank, protects us as regular, everyday individuals. Copyright, I'll explain to you what that really is. False association, which is a trademark concept, and how trademark laws apply. So this is a fundamental point I think you need to understand, which is really the difference between advertising and editorial. So for example, what do we mean by advertising? As I just talked about, the fact that you might be in a different range of media, and to be frank, and the media may not be paid media, that is not the sole determining factor as to whether in fact it's advertising versus editorial. And by the way, editorial is as I said in the next bullet, are things like news, opinion. It'll be entertainment, it'll be a movie, it'll be a film, it'll be a book, it'll be the New York Times, it'll be the LA Times. And that content is treated differently under the First Amendment than advertising is. So First Amendment protects non-commercial speech, which is, again, what we probably see in terms of our media that we use to digest and get news or entertainment content. But commercial content is subject to protection under the First Amendment, but only as commercial speech. It is a much less protection than would exist. And something like branded content is going to be viewed as being commercial speech. So let's take it to real life. So here's PerezHilton.com. So we see, recent on the homepage, kind of a discussion of what's going on during, the recent event where they won a bunch of awards. Stranger Things won a bunch of awards as part of the process. So what is this? Well, yes, it's PerezHilton.com. There is a PerezHilton.com. And yes, this may contain a lot of kind of things which are just you may or may not view as being news-like, But is this protected by the First Amendment as editorial content? The answer is absolutely yes, it is. Go to Pop Crush. So here again, you have Luke Bryan performs the national anthem in Super Bowl. What about what happens here? Well, do you need Luke Bryan's permission to appear on this particular either image, or if it's a video piece, a video piece? The answer is no, you don't. Why? Because you have a right to do that under the First Amendment, to be able to take that and comment on it as part of the content that's here. Even again, if that content is viewed as being not the most newsworthy as part of the process. Here again, this is, for example, my blog for Madison Ave Insights. And here I'm talking about some legal issues that are ongoing, but do I need to get permission if I start talking about a particular celebrity, for example, or if I use an image of a celebrity? As a matter of copyright, I would have to be concerned about that. Going back to here, for example, this photograph of Luke Bryan, they need to get copyright permission. But do you need to get permission from the celebrity? The answer is no, you do not. Same way here in my blog. Or now let's go to Airbnb. So Airbnb, as you saw in the Super Bowl, the recent commercial that was run, here's a discussion about the commercial and about really the social issue that was being discussed. Here we're talking about their efforts to try to house people in short-term housing, including refugees and others. So a very important issue and a very important topic for conversation. But do they need permission to have this discussion? Well, the answer is certainly on a discussion basis, no, but in terms of the content, if, for example, you see again those images of the people on the right of your screen, you certainly would need copyright permission. But if they identified people in terms of that conversation about, again, forget about political figures right now, but let's say celebrities, would they need permission? The answer would be yes, they would. Why? Even though it's very newsy feel-like, and it's no, why is this any different than, let's say, Pop Crush or Perez Hilton? Because at the end of the day, this is a commercial advertiser. And that, in fact, is commercial advertising. So not commercial capital C, but commercial small c. So here again, 84 Lumber. Again, picking up on what was going on certainly in the Super Bowl with their commercial. And here's that continuation or the non-cut commercial. And you'll see this is a very important issue, a topic that's discussed in mainstream media in general, certainly. But down below, you'll see before that, Riverhead stores now open, or Career Path, or National Builder Services, much more things that you would typically see in a regular commercial site. But again, you have to think, what if you're now interacting on, let's say, a brand's homepage or their Facebook page or whatever it's going to be, that ultimately, again, is going to be advertising content. So let's look here. Muhammad Ali. This is from the Muhammad Ali website. They are acting here as a publisher. Now, again, this is, again, a picture of Muhammad Ali. You don't have to worry about that as part of that process. But this is Muhammad Ali acting as my blog, for example, acts. Now let's look at this piece of content. Here we have Louis Vuitton, and we have Louis Vuitton with Muhammad Ali with his grandson. This is obviously when he was alive. And you see some content on the left, some copy. You'll see a visual presentation of the brand. And it's very soft. It's not very retail focused. It's not price focused, which of course is consistent with the brand as part of that process. But what is this? Is this advertising, or is this in fact editorial? The answer is it's advertising. The fact that creatively it doesn't have some of the indicia of what you might think to be more classic advertising in terms of it being a set price or specific, hard comparative claims being made, that's a creative choice, not a legal analysis. This is, in fact, advertising. Look here at a Perrier site. Here we have a retrospective of Andy Warhol's works showing, in fact, an image of Muhammad Ali. So in this situation, what is this? Well, if you go back to what we've just been talking about, this is, in fact, arguably advertising. Now, it might be, again, very soft. It might be very news format presented. In a sense, it's really trying to be less about the product at all. If you compare it to the 84 Lumber website, there's nothing really in here. It's talking about nightlife, art, music, fashion, travel, cocktail culture. It's almost like a magazine, like an online magazine to talk about that. But again, because it's Perrier, and because, again, it's being done for purposes ultimately of promoting the brand and its product, it is in fact advertising. And the advertising rules are going to apply. So what are some of the basic advertising rules and principles? Let's talk about them. Copyright. So this is you're going to learn everything about copyright in like 2 slides. So copyright protects the creator of a work, a creative work. So it could be a text, a book, or some copy from a commercial, for example, music, art, photographs, other works as part of the process, creative materials that are presented. You gain copyright protection by creation, not by putting a little C in a circle, 2017, Ron Urbach, all rights reserved. That's a copyright notice. That's a good thing to do, but that's not necessary for there to be copyright protection. So if you see a work in the marketplace and there's no copyright notice on it, do not presume that it's available to be used. What is in fact public domain is kind of a complicated analysis, not to really, kind of go into detail today. It's kind of doesn't fit into the topic. But simply put, if something was created back in, to give you some barometer, something created back in the 1900s or in the 18th century or the 19th century, is that public domain? Yeah, it is. If it was created during the 1900s, it depends upon when it was created, how it was created, and all that part of the process. So don't presume because something is old, it's automatically what's called PD. And PD, public domain, means you can use it without permission. Example, Wizard of Oz, the book, is in the public domain. Wizard of Oz, the movie, is not in the public domain. So if you show a character, you say, I'm going to look at the book and copy the character. Well, for example, Dorothy in the book wore silver slippers. In the movie, she wore ruby slippers. So if you show a Dorothy-type character that, in fact, is wearing ruby slippers, unless you have permission from MGM, you're going to have a problem. Another important point, the point at the end, just because materials are publicly displayed does not mean they're in the public domain. So, for example, you see a statue out in front of a building. You say a giant mural in a mall somewhere across the country. Does that mean, in fact, you can use it in advertising because it's publicly being displayed? The answer is no, that is not the case. The mere fact it's publicly displayed does not give you the right to use it in an advertising context. And that, by the way, is true whether we're talking about advertising content or editorial content. So I'll go back to my points about, I showed you some of those sites. So if we were all working for for a print publication or a publisher, CNN.com, and we have a shot that was taken, let's say, by me, a photograph shot taken by me, can you use that without permission on CNN.com? The answer is no. You have to get permission from the photographer who owns the copyright. So copyright crosses over editorial and advertising. But if that picture is of one of you, and there's a news reason for that to appear, for example, whatever, it says people working in the ad industry today, and I have a shot of you, I couldn't use that in advertising, but I could use that in the New York Times could use that on the front page of its publication without permission from you at all. So what's trademark? Different than copyright, trademark protects a word, canon, symbol, the alligator, a slogan, just do it, a product or packaging design, the Hershey's Kiss, or the Coca-Cola bottle. Those protect particular elements that may, in the world of advertising, are relevant for us as part of the process. In other words, they are important things to think about as we figure out what we're talking about, which is in social media, when do I have to worry about getting permissions or consents as part of the process of what I do? To make it very simple, to go back again, copyright is not about using it inappropriately. It's not about somebody getting great free press, they're really happy. Copyright protects the ability of the owner to prevent copies from being made. It could be copies that are physical copies. I paint a piece of an artwork, and we now make limited edition prints, and now we sell them. That's copying. Or we, in fact, perform it. We have a symphony that we all wrote, or a song that I wrote, and now it's being copied by somebody else or being taken by somebody else, as you see in a lot of the music copyright cases. The owner controls that because they have the ability to control how it's being used going forward. Trademark is not that way. Trademark is based about a confusion standard, for example, in advertising. So Canon can say, buy the new Canon XYZ camera, it's better than the Nikon. Do they need permission from Nikon? No. Why? Because, in fact, Nikon is, in fact, a trademark of the competitor, but you can use that in a comparative context. So in your social media, when you make reference to third-party trademarks, Is that going to be a problem by itself? No, it's not. It's contextual. The question is going to be the way the mark is being used. If it's being used for comparative advertising, so in a social media post you're saying, buy the new BMW X is better than the Mercedes-Benz Y, it's pretty clear that you don't have any, that you're not somehow creating any, what the argument is, confusion, because the confusion is not going to occur, because what's happening is it's going to be clear you're talking about BMW on behalf of its BMW making claims against Mercedes-Benz. But if you just happen to put just random trademarks, either, for example, in video content, they're just appearing there, and it just appears for purposes of creatively making it appear more realistic, then that could be an issue. So again, it's contextually driven. All right, so what are some of the risks with using social media content? Here's an example. Let's see if this works, and if it doesn't, we'll move on.
Priorities first. I want to go kiss my wife and my kids. I want to go, hug my family. I'm going to drink a lot of Budweiser tonight, Tracy. I promise you that.
So that was last year's Super Bowl, if we can remember that. And that, there was a fair amount of chatter about this after this occurred, where Peyton Manning was going out and talking on more than one occasion about basically drinking Budweiser. So the questions that came out involved multiple issues. It's going to be about, and here you'll see some of the discussions that occurred in social media thereafter, including even from Budweiser, saying congrats to Peyton and the whole Broncos team. Where would one ship 50 cases of Bud? Just curious, hashtag this Bud's for you, and other kind of commentary ongoing. Now, under the law, forget about the rights of copyright or the rights of trademark or the rights as it relates to celebrities, for example. In the situation of the governmental issues, are there concerns? Yeah, there would be a concern, because if at the end of the day, Peyton was being, in a sense, a representative or acting on behalf of Budweiser, and that's undisclosed, that in fact is a potential violation of the law. So that becomes important, whether it's going to be in terms of traditional media or in terms of non-traditional media, and social media or mobile or whatever else it might be, that you need to have a disclosure of the relationship between a particular individual / celebrity and a particular brand if it's not clear by the circumstances. And that's more often the case in social and digital media than it is in traditional media, because if in traditional media it's pretty clear that this is occurring in a paid segment. So if this was Peyton Manning talking literally during a paid commercial spot, this obviously is not pre-recorded, even if it was a live spot, do we have to disclose that there's a relationship between him and Budweiser? The answer is no, because it's presumed. But if during the course of editorial content, he starts talking about, in a sense, a product or a brand which he has a relationship with, then there's a need to disclose that relationship. And that is the case in social. Because in social, it just naturally flows into my point originally, into the conversation. And if all of a sudden somebody starts having a kind of conversation, even if somebody, for example, a celebrity posts something, is it clear that that celebrity is doing it because he or she thinks it's a great product or a great service or a great idea, or they're doing it because they're a paid spokesperson? If it's well known that they are, Tiger Woods does it and he's doing it for Nike, you probably don't have to disclose. But if somebody who is not, you're probably going to have to make it clear that that person is doing it not simply because they want to, but because they're being paid to. So what are some of the so-called right of publicity risks in social? Well, just to take a big step back, just so you know, the right of the publicity is the right of a person to control themselves, their name, their voice, their signature, their photo, their likeness, their persona. It's a property right. It's something that they control and they can monetize. And therefore, again, it's not about how it was used or how nice they were presented or it's free publicity for them. It's not about that at all. It's about the ability for someone to either control it because they don't want it to be used, or they can control it and monetize it and make money off of it. That's important to understand. So therefore, when issues come up with celebrities, it may be because they don't want to be associated with the brand, or because they say, you're denying me the opportunity to make money. And that becomes important. And so even in a conversational context in social media, those are kind of the goals or the interest of the particular celebrity as part of the process. The image on the right, so that you can see it, just show how crazy it can be. This is an image from a case that was brought against by Vanna White, where here you'll see what appears to be Vanna White as a robot being done for, that was the case with Samsung. And even in this situation, because of the context communicated, it was her. It was a robot, a blonde wig, an evening gown, the kind of content that relates to the particular game show that it was, that in that circumstance, she still had a right to be able to stop that. There's also laws that exist in the states on this, and this is just something so you understand what this is. There's something called the Lanham Act. It's a trademark statute, but fundamentally it's the key statute that's being used both in terms of false advertising by competitors. So in the other parts of what you do, if you're concerned about a competitor suing your client, or you, if you're at the agency as part of the client matter you're working with, for doing advertising where claims are made and for which you have no substantiation, let's say, as an example, and a competitor says, I'm going to go after you for that because that's not true, they would be using this statute. It's also used by celebrities and others for purposes of the following. Basically, a celebrity who says, your use of my name, as an example, violates the right of publicity, which is the right to control their persona, but it also violates something else. You are associating me with the brand that creates the implication or the express representation that I am somehow endorsing or tying in or associated with you in some official capacity, which in fact is not true, assuming what's the facts of that. And that is what's used there. And so that would be then a confusion standard. So then, very simply put, the way you prove that is by way of actual confusion. People write to the celebrity or write to them and said, hey, I didn't know you did a deal with Budweiser. Well, that's pretty cool. Congratulations. Well, that's actual confusion. Let's assuming that Peyton Manning thing obviously was tied into Bud, but let's assume there's some other situation where there's a connection between Peyton and Budweiser, and it wasn't true. Or you prove it by way of consumer testing, where ultimately consumers are asked, what do you think? And if the answer is they believe there's a connection, then in fact that supports the argument. So it's a confusion standard, which is something we talked about in the trademark context, what trademark is about. It's not that you prohibit it, is it confusing the relationship between two companies. So let's take this to real life. So this is the Pharrell case, the Pharrell matter. So here it was where back in 2014, where at the Grammys there was people saw Pharrell kind of appearing, and someone said, hey, looks like Arby's logo. It's what he's wearing on his head. And there was a lot of social media chatter all about that. And here even Arby's said, hey, Pharrell, can we have our hat back? Hashtag Grammys. So, and here's some of the chatter that all occurred as part of this process. Chatter by individuals, by other brands, by Arby's itself. Now, let's analyze this. Some of the things we just talked about. Let's go back to here. Well, first of all, the law would say that if Arby's is using Pharrell's name here in advertising, which this is advertising, again, may not have been a paid post, but it's advertising, does Pharrell have a cause of action, a potential claim against Arby's? And the answer to that question is yes, both in terms of the right of publicity, as well as the argument in terms of the Lanham Act we just talked about, where Pharrell could claim to say, hey, wait a minute, some people may think I'm doing a deal with Arby's. You may agree, you may disagree, but that would be an argument. Another part, just staying with this tweet right now, it says, hashtag Grammys. What about that? Well, there's an argument, and there's a discussion, again, in the time with big tentpole events as well, specifically, is going to be, is Arby's, in a sense, tying in with the Grammys? And let's assume, for sake of a hypothetical, that McDonald's is the official fast food supplier, if you will, to the Grammys. So McDonald's sees this and gets pissed off as hell and says, I just paid you, Grammys, a whole bunch of money to be the exclusive provider or kind of tie-in partner with you. What's going on here? Do something. So again, What would happen here if on those issues would be this is a trademark issue. It's not a copyright issue. And because of that, then the argument of the Grammys would be, hey, do I have an argument that I can bring against Arby's? Forgetting about whether I want to bring the claim or not, but do I have an argument? And the answer is yes, they do. And there are various big name events that occur where, in fact, they've been quite aggressive. Now, again, we can say some of the following, like who started the conversation? Did Grammy start the conversation? Did Arby's start the conversation? Did all of these people start the conversation? Does it make a difference legally if, in fact, the conversation was ongoing and Arby's just jumped on board later on versus Arby's starting the conversation? I think the answer is yes. I think that legally, as a matter of just practicality, if this was all over Twitter and then Arby's jumps into it, that's a lot different than Arby's sees this and just goes out there first. Now, what happened? This discussion stands for the kind of proposition. Let me see if I have a slide on this. No. That discussion, that relates to what happened. Well, what happened is that Arby's and Pharrell got together after this, and basically Arby's agreed to make a donation to charity based upon a sale, if you will, of his hat. And the result of that was it was a win-win for everyone. Arby's got some nice press. Pharrell looked like a good guy. A charity benefited. It was all really great. So this is a kind of you go back to the video at the very beginning, this is sort of like you pull a Pharrell. That's kind of like what's kind of talked about in the vernacular. This is the opposite result, though. So this is the Katie Hagel case. This is an actual case, and we were involved with this. So here you'll see this. This is a, you can see it, but I'll read it. Love it quick, hashtag Dwayne Reed run. And for those of you not from New York, Dwayne Reed is now owned by Walgreens, but it's kind of a large pharmacy chain here located in the New York metro area. Katie Hagel can't resist shopping at hashtag New York City's favorite drugstore, etc. And so what do you see? You see a photograph of Katie Hagel walking out of Dwayne Reed carrying 2 Dwayne Reed bags. This was a paparazzi photo that appeared on the on the web. Go back to what we just learned about. If I'm the photographer, I'm the paparazzi, I shoot this, I post it, I see Katie Hagel and say, hey, look at what Katie's doing out in the marketplace today, or what she's doing today, on Monday. What do I have to worry about? Well, I'm a publisher. I did it myself, right? And I own the copyright. Do I have to worry about Katie Hagel? No, I don't. I don't have to worry about Katie Hagel. Now, the retweet or the reuse of this photograph by Dwayne Reed. Dwayne Reed runs the risk of, if they don't have permission from the photographer, but using the copyrighted image without permission, of the photograph without permission, and the photographer would have a claim. The second part, and the one that this relates to, is what about Katie Hagel? And here, Katie Hagel has a claim against Dwayne Reed. What are the claims? One is saying she has the ability to control, under the right of publicity, her image, or who she is, her persona, in advertising without permission. Simple. And in fact, this is advertising. So if this was a television commercial, so everyone can agree, and we have Katie Hagel walking through the scene, you need permission from Katie Hagel. You also need permission in the social media context. The other argument she has an argument under the Lanham Act, which we just talked about. The Lanham Act, again, is confusion standard, but it's an argument to say that is there an association or connection between Katie Hagel and the brand? Well, the answer to that question is, of course. Why? She's walking out of the store carrying 2 bags from Dwayne Reed. That is, if that's not an endorsement, then what the heck is? And you look at the content, it says, even Katie can't resist shopping at New York City's favorite drugstore. So between the content and the visual, the copy and the visual, it's very clear as to what exists. Well, is this going to be like Pharrell? So what happened? She sues for $6 million for posting it on Twitter and Facebook of her leaving the drugstore. Now, you might think to say, well, wait a minute, it's just a simple little blip, used, one of the things that happen, on social media. It lasts for 2 seconds. No, everyone looks at it and you move on. No big deal. Is this worth $6 million? Well, there's two discussions in these legal cases, or three discussions. One is going to be, is there a legal claim? And the answer we've just talked about, the answer to that question is yes. The other part is going to be, well, maybe a step even before that, is this going to stimulate an action? Let's assume we're all working together and we said, I'm going to do this. Can I do this? And we talk about the legal issues. Then we get to a practical discussion and say, well, what do we think about that? Well, I would have told you. I said, well, first of all, Katie Hagel is known for being particularly cantankerous. She is tough. She is, has a reputation for kind of knowing what her rights are. And if you're going to do this to anybody, she's not one you would want to pick on. So practical risk, probably high. Legal risk, there's very little defensibility here. So the only thing you'd be defending on is going to be about, well, what are the damages? So you might say, well, this is worth $6 million. It's not worth $6 million. So what would this be worth? $1,000, $2,000, $5,000, whatever you think it might be. The simple fact is going to be is that the way the law works in the U.S. compared to the UK and other countries is that nothing prevents Katie Hagel from suing. And if she sues and she loses, she doesn't have to pay your legal fees. So there's no downside for her to go after you if, in fact, she feels wrong. And when you then confront her lawyers, which we did, and you then say, this isn't worth $6 million, they'll say, that's fine. You're going to be spending hundreds of thousands of dollars to prove I'm right or you're right, or I'm wrong or you're right. You want to do that, or you want to pay me a bunch of money now? So the practical process of what litigation is may force discussions about settlement, and in fact, the big issue is going to be what, in fact, the person wants. And that just defines the ballpark within which you negotiate. So again, it's important to understand, because this is an application of basic advertising rules to what occurs in social media, and then there's some lessons here in terms of kind of refuting what you might ordinarily think. That even though something is there for a nanosecond in social media, and even though it may not, just be kind of blend into the background, don't assume it's not going to be picked up. Don't assume it's not going to be a stimulus for an action, and don't assume it's going to be a Pharrell versus a Katie Hagel. So what happened in this case? This case was settled. I can't go into the detail. Let me just see if I have anything on it. No, I don't. What happened was there was a deal struck. This is the public part, where there was money given to a charity that was in fact something she controlled, but there was, the discussion was there was a substantial payment made to resolve this matter. And from the agency versus the client part of the process, kind of a practice tip point for you, under your MSAs, your agreements with your clients, the brands, usually these types of issues are your risk as an agency versus the brand. They're going to look to the agency to say, it is your responsibility to be responsible for things that you're supposed to be experts in. Copyright, trademark, rights of publicity, use of celebrities. Those issues, you're supposed to be experts. We, the brand, we make widgets, we sell services. We'll cover you on product claims. Hopefully they will. But on this area, you're going to be responsible. All right, we talked about this. This was just shows how social media continues the conversation. Here's Piers Morgan after the Katie Hagel case came out. He said, hey, I'm happy to be photographed coming out of your excellent stores, and feel free to tweet it whenever you want. Okay, let's talk about a few other things. So was Katie Hagel a one-off? No. Here, Kendall Jenner seeks at least $10 million from Skin Company for unauthorized advertisement. And again, you might say, I'll use the reference here, pseudo-celebrity. The celebrity status of an individual, whether you might think are a major celebrity, sort of grade B, grade C, whatever it might be, or to be frank, a regular everyday individual. The fact that you're not a celebrity, the fact that you're an individual, you have the same rights as a celebrity. You may not be getting $6 million, but you still have the same rights and issues. Let me see if this works. No, it doesn't. Okay. This was a spot, and you might think, who is this? This led to an actual case. This appears, in the person in the middle, to look like Kim Kardashian. It's not. And there's a whole case and discussion about this involving, this is Old Navy. I won't go into the details, but just understand the fact that even if you use an actual celebrity like Katie Hagel, and you use somebody that appears to be somewhat like a celebrity, like in this case Kim Kardashian, the claims still exist for the celebrity to bring a case against you. And that's true whether in social or otherwise. Here again, references to the celebrity. Here's a reference even without the celebrity, okay? This is Jewel Osco, a retailer in the Chicago area, and when Michael Jordan was kind of put into the NBA, kind of, celebrity to be put into the Hall of Fame, Jewel Osco ran an ad, so-called congratulatory ad. And this happens in social media all the time, especially after events that occur. Congratulations, blah, 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 and winning the whatever it might be. Is that okay? The answer to that question is it's okay in the sense I understand the reason and rationale for wanting to do it. I understand it's going to be used, probably once. But does that give, for example, let's assume it was congratulations, Tom Brady, on winning MVP in the Super Bowl, and you happen to be a brand. Can you do that? Well, the answer was, here, Michael Jordan filed a $5 million lawsuit for this particular ad. This went through a long process of fight over this. And here again, there's not even a reference to Michael Jordan. I mean, in terms of his name, there's no likeness of him. This is the colors of the Chicago Bulls, his number, 23, and saying congratulations to Shoo-in. Context drove identification as to who this is. Context drove the potential cause of action. Cause of action exists. So even so-called congratulatory ads are part of that process. Here again, this is Sofia Varga, another case that was brought in social.
Carpet, every magazine cover, every Sofia swimsuit pic, flawless. Now we're revealing Miss Vergara's super skin secret, this machine. Beverly Hills dermatologist to the stars, Dr. Harold Lancer, says the Venus Legacy is a non-surgical tightening alternative, not just for the legs, but for the whole body.
Okay, so there you have the news content, I'll use news in quotes, but news content that you see occurring on television. And do they have to worry about, as the news program, in terms of getting rights from Sofia Varga? The answer is no. They have to worry about copyright rights. We talked about that. Let's assume that's all been cleared. But here what the issue was about the doctor had been running some social media post that showed, in fact, which she had, in fact, Sofia Varga had, in fact, actually presented was in Twitter or whatever it was, what social media platform it was, that showed her using the exact product. She can do that. The fact it's publicly available, people can see it. It doesn't give him the right to go ahead and use it for his own business commercial purposes. She sues for $15 million. Now, you might say that's just simply like, again, it seems crazy, and it's just simply just conversational what's going on out in the marketplace, but that doesn't give you the right to do it in a commercial context. She sues. This led to a long fight again. Case ultimately is settled. Here's another one. Example, this is for Airbnb. This is involving a kind of a potential contest, and there's a reference to Julia Child as part of this. Julia Child's estate sued, or went after us for that. And again, based on all the things we just talked about. So copyright risk. Again, we talked about copyright, which again is, you might hear words like fair use. Those of you maybe took some business law in school, or you might know about this in terms of creatively what exists. Fair use in the context of copyright as it relates to advertising is very, very difficult. Fair use is more likely thought about in the context of a First Amendment for purposes of editorial use, and whether or not the use of copyright in that context is a fair use. But in terms of advertising, it's much more difficult to do. So again, it's better to think of it in terms of the simple fact I said before, which is using protected works without permission in an advertising context, even if it's social or digital, would require you to consider getting permission. Oh, and by the way, this is important. If you then say, well, wait a minute, under the platform terms of use that exist under Facebook or Twitter or Instagram, YouTube, Pinterest, etc., Vine, no longer Snapchat, Snap, no longer Snapchat, Snap, the terms of use seem to give you the right to do that, right? Isn't that all what it's all about? It's supposed to allow people to share. I mean, that's what I do. When I'm on, I'm on a particular platform, I share it with my friends. Can I do that? And the answer is you're right. That is, in fact, what it's designed to do. Those terms are allowed to create this kind of communication that occurs with you and your friends. But it's not designed to give protection for brands to be able to take the content that's on a platform and use it for their purposes on a business basis. And you can't use those as defense against that. And there's cases that speak to this. Example, this is a case involving this photographer who's taking some very dramatic shots of the devastation that occurred in Haiti in the earthquake. He had posted them on a social media platform, was picked up and used in a context other than what he had authorized. He went after them. He ultimately then won on the basis of, one, the merits, because it was using his copyrighted work without permission, and two, the terms of use that existed didn't give the one who used it permission as part of that process. So if you need permission, you have to go to the owner. You can't simply rely upon a platform's terms of use. These are some of the images that were used of his. Let me move over this. Let's talk a little about trademark. So you may have seen this, but let me run it.
Here we are, guys. Samsung, the next big thing. You two, ideas.
We know that it's got to be big because it's for the Super. We can't say.
You can't say the name of the game.
You can't say Super.
Shut up.
We actually can't say Super.
No, it's trademarked.
Why can't we say?
We can get sued.
By who?
Everybody, nobody, who knows?
Wait, so can I say Super?
Yeah.
Am I allowed to say like? Can I say San Francisco?
Sure.
But I can't say the 40.
Can I say the Baltimore Ravens?
Can we say the San Francisco 50-1s?
Love it. Can we say the Baltimore Blackbirds? Absolutely. All you want.
Okay.
So then what do we say instead of Super? The big game! So what we... El Plato Supreme!
The big plate?
Doing a commercial for the big plate featuring the San Francisco 50-1ers and the Baltimore Blackbirds. You got it, Paul. You got it. I like hashtags.
Hashtags. Okay, we'll use hashtags.
So funny spot, again from a little bit ago, but it stands for probably a couple things. One, which is the sensitivity to being able to use a trademark in advertising. Sensitivity as it relates to certain types of trademarks being used in advertising and who the owners of those marks are. Example, the NFL, who has, again, go back to my Katie Hagel point, has a reputation for being extremely aggressive about trying to protect its rights. The workarounds that might exist in the industry as to how to get around it. So this was kind of a cute little kind of play off of playing with what are the alternatives to saying Super Bowl. Can we say big game? Can we sue this? Can we, going on and on. And the answer is, yeah, those are common workarounds that might exist. But again, it goes back to kind of a fundamental point, which is if you had hashtag Katie Hagel, it's very simple, which is you can't, it's her name, yes. You can't use her name without permission, absolutely. You can't. If it was used without permission, it's game over. The only question is how much. If it's hashtag Super Bowl or hashtag something else, and it's just a brand name or a product name or an event name, it's a trademark issue. It's not a right of publicity issue or a copyright issue. So it's both good and bad. So therefore, if you were being more aggressive, and let's assume it wasn't with the NFL, it was somebody else, and we all worked together and you said, here, guess what? We think this is a reasonable position to go off and say hashtag X or whatever it might be. Can we do that? We understand the risk. We figure it out. We think the risk is reasonable, and we progress forward, and then we can figure out how to really deal with it. And that may make some sense. Because, again, it's not an absolute bar. It's a confusion argument as part of that. But go back to these workarounds. So if you did a commercial like they're talking about, where you kind of just continue to come up with these references to the event, would you just change, kind of disguise the trademarks and call it a big game or Blackbirds or whatever you want to say? Then the question still remains, though, if I'm the NFL, which is to say, wait a minute, you've tied in with me. And yes, you've done it maybe not by using the actual proper names, but you've done it by context to really drive a connection. And that may be a violation of the Lanham Act. So the risk could still be there. So my point is, as you might, are now more educated about these issues, or you were educated before getting on the call with these points, and you might say, all I have to do is just change the name and come up with a workaround. That doesn't necessarily solve the problem. So you need to think about it much more in the context. So if the campaign was an integrated campaign using social and digital and experiential and PR that's tying into an event, but you kind of use all these references that are not really the name of the trademarks, have you solved the problem? Well, yeah, it's better than using the actual names, but it's not that the problem is resolved simply because of that. Because again, it's still about the question about being tied in. Also, something to be aware of now is that a number of the larger events have now come out with their own social media policies in terms of how they, on a commercial context, and how they are willing or not willing to have their names or trademarks used. So the Oscars, which in the past have been quite aggressive, have now last year issued policy in terms of what they think can or can't be done. Because, and I think it's much more enlightened view, is to say at the end of the day, there needs to be a balance between having a prohibition and really wanting to ensure what you really want to have, which is having people actually do engage in a conversation around your event. That ultimately benefits the event much more importantly than somehow just controlling in an arbitrary way the way their names are. So there's a balance between that. But again, think about the important thing. If you have a brand and you are ultimately then trying to kind of connect with an event, for example, and reason why you may try to be it much more less directly, because in fact there is an official, one of your competitors is the official sponsor of that particular event in that product category, then you need to consider this not only in terms of trademark law and copyright and all the things we're talking about, but think about it in terms of ambush marketing. That's really the discussion, which is, am I putting myself or I'm putting the brand at risk by going ahead and trying to connect with this event in some way because I can't do it officially. And that may very well be defensible, but you need to at least think about the issue and understand what the facts are and how the law applies to the facts. So then if for some reason you run something and you get challenged, then the client doesn't come to you and says, what the heck happened here? And you say, I have no idea what you're talking about. You wouldn't say that. And then they say, well, didn't you know about this? Or why didn't you tell me about this? Or their lawyers say, or they call me up and say, well, why didn't we have a discussion before this ran? That needs to be thought through. And that's sometimes is where this is being driven by economics as opposed to a non-economic concern. Here's again some other examples of so here's like the most recent Super Bowl, and you may have seen this was a Ford spot, and this is also what happened. So no one likes being stuck. Ford Super Bowl ad shows frantic cat trapped in tissue box. Tell them harassing animals for ads is wrong. Now, if you saw this, it was cute, funny, harmless. But again, this could have been done as part of a social media campaign. I'm just picking up the social media response in terms of PETA. PETA is, if you use animal in advertising, just as a practical example, and you do something where they're doing some type of trick in some way, they're going to be all over you. And PETA is quite aggressive. And in terms of media sensitivity, go back to practicality, if you have a spot that's going to run going forward on broadcast, the network might be very sensitive to that. Social media platform is not going to be. It's much more about more of a free flow in the discussion. But that could be a concern. But here is an example of we are concerned about legal issues, but in fact you sometimes may also have to be concerned about, in a sense, the consequence. Which again, as long as you're willing to deal with that consequence, especially with like some of the spots around the Super Bowl this year, that's okay, but you just need to think about it so you're making an intelligent risk decision and not one that's just simply presumed. Again, here's some examples of how one would be saying, if I'm the NFL or if I'm DiGiorno's Pizza, to say, I'm saying hashtag Super Bowl. Okay, I mean, that's fine, but do I run a risk if, in fact, based on all the discussions that we just talked about? The answer is, yeah, probably you do run a risk, you're better positioned to be hashtag big game. Or you might simply say, I'm willing to do this because I'm willing to take that risk because I understand what the risk is and I'm willing to deal with the consequence. That's a different discussion than just not even thinking about it. So some of the kind of the key do's and don'ts, just to think about. Try not to suggest an endorsement or association between the brand and the event. So again, if you're trying to just comment as opposed to tie in, better. Speak about it almost as a matter of public fact. Again, you're talking factually what occurred. Avoid known high-risk trademarks. Olympics, here, good example. Olympics, not only just the trademark issues that we've been talking about, but Olympics is in fact protected by federal statute. You cannot use the word Olympics in advertising without permission of the USOC. Simply, and it's there for a lot of reasons why that exists, but that's just the statute. So there's a lot of kind of stuff that applies in terms of your use that you want to consider that in fact could impact upon what you talk about and the way you talk about, even if it's social media discussion. Competitor, just think about, the social media discussion in terms of what do you say about your competitors, because you're making claims. It's the same context if you were doing something more process-driven and more bigger production, like a TV spot or a print ad or whatever it might be. A claim is still a claim no matter what occurs. So in most of the false advertising cases that I'm involved in for clients now, typically there's going to be one of the many points of challenge are going to be things that were said about the competitor in social media. In terms of trademark, again, do you just keep talking about Super Bowl over and over and over again, or just one time? Go back to safer to post if other brands are posting. It's like the Pharrell point, if everyone's talking about it, and you're the hundredth company or person jumping in, better situation, you're the only one. And again, the extent to which you have time, talk to legal before you go ahead and do what you're going to do. Here again, you can tie it to context. Here, power out, no problem. This was contextually when there was a big power outage at an event, but you don't really have to talk about it during the Super Bowl. You just kind of talk about it in context, so it's a reference, not really a specific reference to Super Bowl at that time. Should a hashtag be treated in the same way that you come up with like a brand name or like a new slogan? So the ultimate driving machine, Coke is it, just do it. Those are slogans. They are trademarks. You have to pre-clear them before you go ahead and use them. What about hashtags? You have to be worried about that. Let me just show you some examples. So this is Kellogg's. I'm good with butter, maple syrup, pretty much anything. Hashtag happy breakfast. Well, in fact, there's a registration, a trademark registration for Sara Lee Foods. Sara Lee is a direct competitor of Kellogg's. Hashtag happy breakfast. So if I'm Sara Lee, I'm their lawyer, I'm going to basically go after Kellogg's and say, wait a minute, you're using my trademark to help promote your product. Now, the flip side is there on Kellogg's part, I would say that's just such a generically sounding set of words, happy breakfast. If you said happy meal, McDonald's, right, I'd be more concerned about that. But happy breakfast? So one of the debates here is to say that the protection that Sara Lee is entitled to is very narrow, very limited. The flip could also be true if the challenge comes across, goes to the head of Kellogg's, and someone at Kellogg's said, wait a minute, we did happy breakfast and we used this hashtag. Why didn't someone check it out before we ran it? Why didn't we do a trademark search before we ran it? So you need to think about, in terms of how you use hashtags, do you go ahead and pre-clear it like you would pre-clear a slogan? Depends. We'd have to talk about it on a case-by-case basis, but at least there are examples like this which raise the point that you may never know what you're stepping into. Here, again, you have to sometimes think about the hashtag itself for other reasons. Here, DiGiorno Pizza in this context, hashtag why I stayed, you had pizza. Well, this was why I stayed. This happened right around the time when Ray Rice, if you remember, the NFL player, beat up his wife in the elevator, or outside the elevator, in and outside the elevator, to be frank. And there was a hashtag why I stayed, kind of talking about women being assaulted and whatever happened. And this then runs, and then they use this, and then does it lead to a legal issue? No, but it leads to a whole, a whole lot of hurt here in terms of what the issues are and the sensitivity to the concerns. So I've effectively gone through probably about a third of my content. I've run out of time. I guess we could see if there are any questions that are there, and I'll try to answer some. And if not, maybe what we could do, since I've cut into your time, and I apologize for that, is maybe we can capture some of the questions and I can respond to you with those questions. And whoever has a question, I can respond to them. But
yeah, for sure. And everyone's going to get a copy of this deck if and only if you fill out our survey. It only takes 2 minutes of your time. So you fill the survey out, you can get the deck to kind of see what else Ron planned to cover and kind of get some of that great content. But we did get one question, to be honest, I'd love to ask you, Ron. What if agency creates concept which violates protected rights? Inform client of risk, but client chooses to move forward. Is the client still the responsible party?
It's a good question, and it really depends upon the contract that really exists. So, for example, if you're an account person and you think my job is to make sure that people are informed as to what actually the issues are, and once I do that and then the client understands that, even if we then document it by way of, let's say, an email communication, and even let's say you said, by the way, we think it's a risk, and the client said, I hear you, but I'm still comfortable proceeding, go ahead, is the agency protected? The overarching MSA, Master Services Agreement, or Agency Client Agreement may provide, let's assume, the following. It said that issues like that was just discussed that you had with the client are in fact the responsibility of the agency. And even if there's conversations that occur between the agency and the client, it does not amend the agreement. So you would have a moral position to say, hey, wait a minute, I did my job, and the client, assume your counterpart at the client, said, okay, proceed. And the senior people within their the client, or their lawyers, or their financial people look at it and said, well, that's fine, you're right. Our assistant brand manager said, okay, and she was fine, she said that, but that doesn't restrict our ability. So what you really needed to do, you really needed to get, in a sense, either a specific indemnity from the client in writing, or technically you needed an amendment to the agreement. Now, that seems like sort of like an overkill, but it depends upon the issue. But I think it's important to realize that the mere fact of communication to the client does not necessarily shift the risk, the legal risk. It may shift the moral risk because, in fact, now you at least could say to somebody, unless they deny it, the fact that they understood the facts and they proceeded anyway. But I've been in, unfortunately, more situations than you like when they said, well, you know what? This is what the clients will say. The clients will say, that's why we have the agreement in place that way, because we need to protect ourselves from our low-level people making these judgments when they shouldn't be. And it's your responsibility, agency, to know that. And so you, in fact, if you really wanted to shift the risk, the only way you could have done it was by following special procedure, 1AA, which requires you to do whatever it might be.
Okay, fantastic. So I see no more questions came in, so I think everyone is fully informed of everything. We just want to let everyone know that we thank Ron for being here, kind of going over these great examples and guidelines for you guys. But again, this is not the 4A's giving you legal advice. So if there's anything that you have questions about, we do ask you to please talk to your legal counsel. I know all agencies have one. So if you have any questions, definitely check in with them. This is great content to give you kind of an overview of how things have transpired in our industry and with brands to kind of keep you this stuff on your radars. But again, your legal counsel is always the best people to ask. So thank you again, Ron, for being here with us today. Everyone listening in, thank you for spending an hour of your time with us. Again, this is the Advertising and the Law series. We have a couple more sessions left. If you missed any of the past sessions, you have not missed out. You can still get access to the recordings. If you just purchased that access, you can check out our site to learn more. Again, as I mentioned before, to get a copy of this deck, you just need to fill out our survey, which will come to you in your inbox an hour after this webinar. It'll take you 2 minutes, promise. Once you fill out, you will get a link to the final deck. So thank you all. We hope to see you in our next Advertising in the Law session. Have a fantastic day, everyone.
Thank you.